In this session, we're going to begin our discussion of intellectual property. For intellectual property, what we mean is the book has a good definition of it. We're referring to any product or the result of a mental process that is given legal protection against unauthorized use. So it's the law's way of protecting something that's been created, whether it's a product, um, a work of art, or whatever. We're giving it legal protection against someone either reproducing that product or that literary work or them using it improperly. And so the law will protect uh, creation. And you would want it to do that because otherwise, if something is created, you lose the incentive if you can't protect it. So for a business, what we're studying, it's important to be able to have legal protections for the things that you create. Without those legal protections, then you're not going to have any recourse on or any limitation on your ability to protect what you've created. Because without that protection on it, then someone can go out and a competitor can rip off what you've done and start creating what you've done and may make more money off of it than you. And so, as a business, protection through the four things that we're going to talk about, the four primary types of a patent, a copyright, a trademark, or a trade secret, are important for the business world. It provides you protection from someone basically ripping off your uh, design product, your literary work of art, whatever it may be. But you can have protection through these different types through the law. And so patents is the first form we're going to look at with patents. This is a government granted right that you allows you to exclude others from making, using, selling, or importing your invention. And so a patent is the legal right that gives you control of what you've created. So if you've ever watched the show Shark Tank, a common question that's asked is, do you have a patent on your idea that you've come to present to the investors? And so for anybody that hasn't watched, Shark Tank is where uh, entrepreneurs get to come in and pitch their idea to people that are worth millions or billions in hopes that those people may invest in their product and become a partner in their business. And a lot of times they ask the question of, do you have a patent? And a lot of times they'll have a patent, and sometimes they say they have a utility patent or a design patent, and that's what we're going to talk about in the next few slides. But the patent is what it's a right that's granted by the government that allows you to have the exclusive um, right to making, using, selling, or importing your invention. It prohibits others from using it. And if they were to, you know, make something, sell something that is protected, that you've got a patent on, then that would be infringement. So you've got patent right infringement, you'd have copyright infringement, trademark infringement. Um, that is, and the book does a good job of explaining it, so we're not going into it in this lecture, but the infringement is the point in time in which someone is violating your patent, your copyright, your trademark, and that's where you as the owner of the patent, the trademark, or the copyright would sue the person who's violating it, who's infringing on your protected rights. And there, that would be the process that you would go through in seeking to stop them from violating your exclusive rights and to recover damages that you may have sustained because of their infringement on your exclusive right. So patents, they have a useful life in that they will eventually expire. A patent is not indefinite. And so when it expires, the invention then becomes available to the public. So patents will protect you, but they're not going to protect you forever. And so a patent, though, will allow you to get the most value out of it, and it does provide you protection for a decent amount of time. So the Patent and Trademark Office is the federal governmental agency that's responsible for basically reviewing applications for patents and deciding whether a patent should be granted or not. So the first type is a utility patent, and this is the most common. The utility patent has a lifespan of 20 years. So, like we just said, there are certain lengths of time on these. If you get a utility patent, it gives you the exclusive right for 20 years. After that 20 years is up, then it becomes a design that falls to the public, and someone else would be able to um, remake it, manufacture it, sell it, whatever. There would not be any patent that would prohibit them from doing that at that point. And here, as you can see, there are four main requirements that must be met in order to be entitled to a utility patent. The invention has to be novel, useful, non-obvious, and it has to be a subject matter that is that a patent is eligible for. So not all things are patentable, only certain things. So when we say it's novel, this equates to meaning that it's not anticipated. It's something that's new. It's not something that has been previously known or previously done. So there has to be an element of newness to it. Prior art, uh, this is a common term that's used. It denotes when the invention is not novel, meaning that this is something that is an obvious development of a current invention. So if you take one invention and tweak it just a little bit, this would not qualify as novel, but rather it would be a prior art, meaning that is just an obvious development of something that's already been invented. And so um, you got to decide, is it something that's novel or is it just use of prior art? And so the patent will be denied if the invention was previously patented, if it's been described in a printed publication, or if it's in public use, on sale, or otherwise available to the public before the patent's filing date. So all those things go to the fact that it's not something that's new. So the patent has to have an element of being something new or unique to it. It has to be, it may be that you have an existing concept, but that you added some unique feature to it, and you could patent that unique feature. So if you had a suitcase, for example, I think there was something along this lines on Shark Tank, but if you had a suitcase, I mean, suitcases have been around, so that's not something that's new. But what they had is it was they had some form of it that would allow it to collapse down to next to nothing. And so it would be these hard structures at one point, and then you could do something and it would fold down and you could just slide them up under your bed. And so if in that instance, that whatever they develop, that technology or that process to allow it to break down like that is something that is unique. And so that would be something that wasn't on the market beforehand. And that is not necessarily an obvious development of a suitcase, something that's pre-existing. And so the utility patent could be on not the suitcase, but on the technology that allows the suitcase to fold down to such a small piece to be able to be stored underneath a bed or behind a piece of furniture, wherever it may be. So on the utility patent, the next requirement is that it be useful. So it has to have some practical or real life benefit. Non-obvious, the third requirement, you analyze the invention with the prior art to ensure that there is some element of independence between them. So going back to our suitcase example, there would be suitcases that exist, that's your prior art, but you got to look back and see, is there any suitcase that has been able to break down like this one does? And assuming that there's not, then that would be something that is non-obvious, meaning that there's independence between all the other suitcases and any takes of those and what is currently being sought a utility patent on. So when we talk about only certain subject matters are eligible for a patent, those come down to it has to be a process, a machine, manufacture, or a composition of matter. And these are pretty broad categories to where most things that you're going to seek a utility patent on are going to fall within one of these topics or categories. So, but abstract ideas, mental processes, things that naturally occur, arrangements of printed material, scientific principles, or law of natures are not patentable. And that is probably something that's not surprising. If you go out into the forest and you find some plant that creates some substance, and you find out that that substance is good to fight off insects, it's a natural insect repellent, and you take it and you start um, putting it into cans and selling it, well, that substance that's being produced by the flower is not something that you could get a utility patent on, because that's something that's naturally occurring, and it's not something that you've designed a process for, you've machined, you've manufactured or put together. It's not going to be something that would be patentable. So a design patent, it differs from a utility patent in that the utility patent protects the actual design or function that you're creating. So in the suitcase, it would be the actual material that or process that allows it to break down, not the look of the suitcase or the shape of it or anything like that. All of those things would come into a design patent. So a design patent protects novel, original, and ornamental design of an article of manufacture. So it protects against copying an appearance or a shape of the article. So this distinguishes from utility patents in that utility, you're looking at the function. This, you're based on, design patents are based on the appearance of the product. So a function would not be able to be something that could be patented under a design patent. It would be something that you would seek in a utility patent. So if you'll recall, we said utility patents have a 20-year lifespan, and design patents, you only have 14 years in which your patent provides protection. And when the last thing we talked about was, or the last category is plant patents. So surprisingly, there are enough iterations of people taking and developing new plants that it is a recognized category of patents. And so to be eligible for this, it has to be a plant that is asexually reproduced, meaning that there's some uh, form to it that's not natural. It's not by seeds, so it's something that's being created by man, and it must not exist naturally. If it's something that's natural, you're not really developing anything. For plant patents, you would get a 20-year lifespan. So let's talk a little bit about the process that you go through to get a patent. So going back to Shark Tank, if you watch Shark Tank, there are times where they'll ask, do you have a patent on this? And the entrepreneur's response will be, either I've applied for a patent or I have a provisional patent. And a provisional patent is really a way in which you uh, file really before you're ready. So it's like the inventor giving notice of the intention to file a patent in a future date. So a provisional patent allows you to get an earlier filing date before you're ready to file your full patent application. And so if you've ever looked on products or read it, or heard somebody refer to it on like a commercial or something saying that patent is pending, that's referring to when you have a provisional patent application. So it's where you have filed your provisional patent saying, telling the government, I'm securing my filing date of today. I'm not ready to file for my full patent, but I'm going to go ahead and let you know now, and I'm going to file my non-provisional application within the next 12 months. And so that's when you get the opportunity to say our patent is pending. And that means that you're in this process in which you're still going through and filling out your non-provisional application, submitting it, and going through the processes we'll talk about on the next few slides. So provisional patent is really just the opportunity for an inventor to go ahead and secure their patent date while they go ahead and finalize everything with the product as well as their application. So the non-provisional patent, this is where you have the full application. So you have gotten to the point that you've got all the information that you need to submit a full application for a patent. And full applications are composed of four main parts. The first is the specifications. This is where you describe the invention in its best mode. using the best known method to make the invention as of the filing date. So this is where you're explaining, describing exactly what the invention is and what its best um, method and use is. And so your description has to be specific and clear enough for someone in that field to be able to understand how to make and use the invention. So you can tell that if you've got to be able to explain, one, how to make it, and two, how to use it, it's got to be a pretty detailed description. So the specification can't be just a collapsible suitcase. You've got to tell them exactly what materials used, what the process is that allows you to be able to collapse down that hard suitcase. So the second part is the claims part. Um, this is the important part because the claims portion is where you specify exactly what it is the patent protects. So you describe each element that it protects. So if you go back to our suitcase, you would say it protects against using this material. It protects against having this design or this method of it to it because it's what allows it to be able to break down. So whatever those unique characteristics are that allow you to be able to break that suitcase down, that's what you're going to cover as an element. And if you don't list something and it's not identified as an element, then it's going to be unprotected by the patent. So if you go through and you list, 9 things, and later down the road you decide, well, there are really 2 other things that we should have protected by it. If they're not listed on as an element on your application and approved as that, then you're not going to have any protection for those 2 pieces. And so those 2 items that aren't covered as an element are ones that someone else would be able to replicate or do without infringing on your patent. So the last 2 parts of the application are the drawing of the invention, and that's just what it sounds like. It would be a drawing showing what the invention is. It's kind of like a blueprint for it. And then the last thing is you have a declaration by the inventor. And has 2 main functions. One, it's where the inventor affirms that they're the first to make this invention, that they don't know of someone else having invented it, or that there's someone else that's already invented it before them. And then they declare also or they disclose rather, any known prior art. So that helps identify for the uh, examiner any other similarities in products that they can compare to ensure that you do have something that is novel. So once the application is submitted, then you're going to have an examiner who will review the application. They're going to look through it and look for things to see, make sure that, one, you've filled out everything correctly, because if you haven't, then it's going to get denied for not having met the patent requirement. So if you don't include drawings or you don't have the declaration that you need, it's going to get rejected as an incomplete application. But if you do have all the things there, then they're going to look at it to make sure that it um, is not prior art, that there is something non-obvious to it and novel. If they don't find those, then they're going to reject it. So it's very common that initial applications are rejected, and it's usually because they decide that you don't meet all the patent requirements, or that you've got prior art, prior inventions that are similar to this that make it non-unique. And so at that point, if you do get an initial rejection, then the inventor can either contest the rejection, or they can ask to amend their complaint, or excuse me, their application. And so you would amend the application if you're told that you haven't submitted all the required um, information. If you are rejected for prior art, then you would submit arguments and reasons, explanations why your invention is in fact different than the prior art that caused them to reject it. If you're ultimately rejected, even after you've amended your application and you've submitted additional information, then the inventor can refile the application as a continuing application, meaning that you start all over again, essentially, or you can appeal to the Trial and Appeal Board. And if you're not successful there, then you can ultimately appeal to the Court of Appeals for the Federal Circuit. Now, I want to say one thing. When I said that it's a continued app. You file as a continued application. You basically start all over. Um, I'm not meaning that everything you've done is forgotten about. You would still have your original filing date. You would just submit a new application, and so you would go back to the review period all over again, like you had. You're not, though, beginning a whole new process with a new or a new filing date. Rather, you're just starting over with the examiner looking at everything again. But if you are successful and the examiner approves your application, then a patent will be issued. And that's where, whether it's a design or utility patent, you're going to have protection, exclusive rights for either 14 or 20 years. So in order to have the patent issued, though, you're going to have to agree on the language of exactly what the patent covers. So that goes back to hitting all those elements of what the patent covers. You would have to be sure that you clearly define and that the examiner agrees to it, what the patent will protect. If you do receive a successful application, that doesn't mean that there's no way for someone to challenge it. So usually a competitor is the common person, but you could have a third party that can challenge the validity of a patent even after it's issued. So in these instances, the post-grant review has to be requested within 9 months of the patent's issuance. If that happens, then it's an automatic review to determine that the patent is in fact valid. So this goes back to where they're looking at it again, even though they've already decided once. Usually the competitors coming to them and saying, presenting evidence and saying, this is why it's not novel, or it's not something new, it's prior art, or it's something that is based off of our something that we've done as a patent. And so when they go back and they request that review, they're going to examine your application in light of the information that's been submitted by that third party. But if they don't request within 9 months that review, it's not automatic. If they exceed 9 months, then the third party may request review, but it's not guaranteed. Instead, they've got to convince that board that there's a reasonable likelihood that they will prevail. So they can't just ask them to review it in light of their information. They've got to make a stronger showing. They've got to convince the board that there's a reasonable likelihood that they've got a good chance of winning their request for review. So when you get a patent, you have the opportunity to protect your design or your method of building it, whatever it be, under utility patent, uh, to allow you to have the competitive economic advantage for the effort that you put in developing or researching a product or a process.